My task here today, as I understand it, is to give the background, especially for those who might not be well versed in it, on the Supreme Court's approach to campaign finance regulation. And thinking of the appropriate metaphor to use, the title of this panel is a collision course, which sounds like a crash. And I've often described the Supreme Court's approach to campaign finance as a swinging pendulum. And we just finished a period of extreme deference where the Supreme Court was willing to uphold just about any campaign finance regulation to a period of deregulation, swinging the other way. But I was thinking about this morning, that maybe the best metaphor in terms of how the Roberts Court is approaching the constitutionality of campaign finance regulation is to think about those experiments where they take an insect and they slowly turn up the heat, very slowly, and so that by the time that the insect knows that it's being fried to death, it's too late for it to move off the panel. And I think that that's what's the approach of the Roberts Court to campaign finance regulation has been an incremental killing of the possibility of regulation. And this is showing up more as we see how the FEC has been approaching recent cases, how state regulatory agencies, how state legislatures have been considering reform, that slowly but surely the move is towards deregulation and towards limiting the possibilities under the Constitution of having meaningful campaign finance regulation. So I'm just going to spend about 10 minutes walking you through the history and then turn it over to Don Simon, who's going to talk about the cases that are currently in the pipeline. So there are basically a few different major types of campaign finance laws. There are contribution limits. That limits how much money a person or entity gives to a candidate or a committee. There are spending limits limiting how much money a person or entity spends independently supporting or opposing a candidate. There are disclosure rules. There are public financing laws. Those are kind of federal law has at least started with a mixture of all of these things. In 1974, Congress passed the amendments to the Federal Election Campaign Act, imposed a $1,000 contribution limit on individuals, imposed a $1,000 spending limit on individuals spending relative to clearly identified candidates for office, put in disclosure rules, established a voluntary public financing system, and created the FEC. In Buckley versus Vallejo, which is a 1976 case, the Supreme Court set the major rules which still more or less govern today. The Court upheld contribution limits against a First Amendment challenge. The Court struck down spending limits as violating the First Amendment, upheld disclosure rules, and upheld the public financing system because it was voluntary, struck down the composition of the FEC, which Congress then changed, and the FEC has been functioning since then. My focus is on the contributions and spending cases, although there's an interesting issue now pending in the Citizens United case about disclosure, which maybe we'll get into a little bit later. And I want to contrast the changes from the pre-Roberts period to the Roberts Court. And so just talking about contribution limits first, the Buckley Court said that so-called exacting scrutiny would apply, and there's been a debate ever since as to what exacting scrutiny is when you're trying to figure out whether or not a contribution limit limiting the amount that can be given to a candidate or a committee is constitutional. You'd apply this exacting scrutiny. And what the Court said is that there's a First Amendment interest in giving money to a candidate. It's mostly symbolic. It's not so much the amount, but just the act of giving. And that there'd be only a marginal restriction on speech if the amount was limited, but that contribution limits serve the important anti-corruption goal of preventing the quid pro quo, dollars being exchanged for politicians doing the bidding of contributors. As the Court said, the contribution limits were okay under an anti-corruption principle. The government had a strong interest in preventing corruption, or at least the appearance of corruption. And there's been a lot of talk and thousands of law review pages spent on this appearance of corruption idea. As we went through to the period, when I talk about this, the period just before the Roberts Court, I call it the new deference period. The Court decided a series of cases in which it made it easier for governments to impose various campaign finance regulations. On the contribution side, the Court upheld a very low contribution limit in the Shrink, Missouri case. The Court upheld the ban on soft money. These were large contributions being given to political parties. In the McConnell case, that was the case that upheld the major portions of the McCain-Feingold law, or the Bipartisan Campaign Reform Act. The court upheld limits on contributions to candidates by nonprofit ideological corporations in a case called FEC versus Beaumont, and the case upheld limits on party contributions to candidates in a case Colorado Republican 2. And so the trend before the Roberts Court was it'd be hard to imagine any campaign contribution limit that the court would strike down as unconstitutional, very deferential.